Hello, everybody. Thanks for coming. I hope you got enough Chick-fil-A. If you want more, we've got like 40 more sandwiches, so please help us. So I don't want to take those home. This is the Federalist Society. If you don't know, we're a group of around the nation of lawyers and students that was formed around the idea that the state exists to preserve freedom. The judiciary's job is to say what the law is, not what the law should be, and that the purpose of the state is to preserve freedom. I might have said those twice, I don't know. For today's event, we're going to focus on Texas versus the United States. In 2010, Congress passed the Patient Protection and Affordable Care Act to increase the number of Americans covered by health insurance, decrease the cost of health care, and provide important protections to healthcare customers. The ACA was widely challenged in federal courts around as unconstitutional, particularly the individual mandate that required most Americans to have health insurance or face a penalty. In 2012, the Supreme Court upheld the individual mandate in a 5-4 decision in NFIB versus Severalist. The individual mandate was constitutional as an exercise of Congress's taxing power. In 2017, Congress passed the TCJA, Tax Cuts and Jobs Act, which amended the ACA by setting the individual mandate limit to 0. Soon after, in 2018, Texas and 19 other states, as well as 2 individual plaintiffs, filed a complaint in the U.S. District Court in the Northern District of Texas, arguing that the law's individual mandate provision is unconstitutional, and that the rest of the ACA is inseparable from the provision, and therefore must also fit. The Department of Justice normally defends the validity of acts of Congress when they are challenged in court, but here, DOJ has joined the plaintiffs and has also argued that other key provisions of the law are inseparable from its individual mandate, and thus being violated. California and other states intervened as defendants in the case to defend the constitutionality of the ACA. The district court agreed with the plaintiffs, holding that the individual mandate is unconstitutional, that the mandate is inseparable from the rest of the ACA, and that the entire ACA therefore cannot stand. California and the other intervening states appealed the decision. In December, a 2-1 decision in the Fifth Circuit held that the plaintiff states have standing to bring this case, and that the individual mandate is unconstitutional. On the issue of severability, the court remanded the issue to the district court, instructing the court to explain with more precision what provisions of the post-2017 ACA are indeed inseparable from the individual mandate. In dissent, Judge King concluded that the plaintiffs did not have standing, but noted that if she had reached the merits of the argument, she would have concluded that the individual mandate is constitutional and also entirely separable from the mandate of the Act. 2 weeks ago, the Supreme Court denied a petition for expedited review of the case. Last week, a member of the Fifth Circuit, not a party to the case, moved for a rehearing on bond. Who was it? Alexis is going to come up and introduce our speakers. Thank you for coming.
Should all play.
He's the author of over 4 dozen law review articles, and his commentary has appeared in the New York Times, the Wall Street Journal, the Washington Post, USA Today, LA Times, and other national publications. His recent op-ed in the New York Times was also recently cited in the Senate floor as part of the impeachment. Mr. Richard Salgado is an experienced district chair trial lawyer who focuses on representing companies in high stakes litigation nationwide. He's led more than adults with intellectual and other disabilities. Additionally, he has spoken and written extensively on appellate fairness and diversity. He's a member of the Dallas Bar Association and Stanford Bar Association and the J. Bar Law Society. He's especially knowledgeable about the topic today as a representative of a dozen national disability rights organizations and ACLU as an in support of the constitutionality of the Affordable Care Act for both of their circuit. Please join me in welcoming our two speakers.
Thank you. Thank you so much. It's a pleasure to be here at SMU. I teach at South Texas, which is fairly close, but it's always fun to come to Dallas. We have a debate today. You don't always get a debate, we have a debate today. So I'm going to keep my remarks limited in time so we have enough time to go back and forward. There are three major points that I want to get across for you today. The first concerns standing, the second concerns the merits, and the third concerns what's called severability. That is or do the private plaintiffs in the Obamacare litigation have standing to challenge it, number one. Number two, is the individual mandate unconstitutional? Second. And the last point is, if the individual mandate is unconstitutional, what happens to the rest of the law? Those are my three topics for today. The first issue is, do the parties have standing? And this, I admit, is a somewhat unintuitive argument. In 2010, Congress enacted the ACA, the Affordable Care Act. This law imposed a requirement to buy insurance, as the Supreme Court determined, and those who failed to purchase insurance would have to pay a penalty. Now, I think most people assumed in 2010 that the basis for the injury, the basis for standing, was in fact the penalty, which isn't true at all. The basis for the injury in 2010 was the mandate standing by itself. No one would pay the penalty for some years. Indeed, the plaintiffs in this case said, we will never pay the penalty because we intend to be insured. So the only basis for standing was the mandate standing by itself. So I think the standing inquiry has largely been resolved. The injury, in fact, comes from the requirement to buy insurance. Now, it's a strange injury, right? We don't have lots of laws that tell you to buy something. This is a somewhat unique, novel, dare say, unprecedented law. I think this law was sufficient to confer Article III standing. The second question, which I think is a little bit easier, in fact, is the mandate still unconstitutional? The Supreme Court decided this case in 2012, and the opinion was somewhat complicated. Chief Justice Roberts wrote a very long opinion that covered a lot of ground. I want to walk you through it one part at a time. The first part of the opinion says Congress cannot impose a requirement to buy health insurance. They can't do it under their commerce power. They can't do it under their taxing power, right? They can't do it under the necessary and proper power. Congress cannot make you buy health insurance. That was the first part of the opinion. The second part of the opinion says, but we have a duty as courts to find ways to uphold laws. And if there's a reasonable way to read the statute to uphold it, we should adopt that construction. Did the ACA actually impose a tax on going uninsured? No, Roberts said. However, we can treat it as if it did. Why? The penalty is assessed by the IRS. It's paid along with your taxes. The IRS uses traditional tools to collect it. The penalty raises revenue. All the characteristics of a tax are present. And because the ACA resembles the imposition of a tax, we can read it in that fashion. Okay? So the first part was, it's not a tax. The second part said, well, it could be a tax, maybe it's constitutional. The third part is, we'll treat it as if it were a tax. Right? That's the structure of NFIB versus Sibelius. Where does that leave us now? In 2010, Congress enacted the Tax Cut and Jobs Act, the TCJA, which Dan read from you a minute ago. This law did not repeal the mandate, no matter what people say, it didn't do that. All it did very little for the ACA, was reduce the penalty from about $700 a year to $0 a year. It didn't repeal the penalty, it just changed the amount to $0 a year. So you might ask, Josh, what is a $0 penalty? Well, for one thing, it's not a tax, right? A tax has to raise some revenue. A tax has to be something you can collect, and there's no longer any tax. And let me ask Josh, wait a minute. If the penalty is $0, why is there standing? Okay. The injury from NFIB was never based on the penalty. It was always based on the mandate standing by itself, and I'm pretty confident in that position. And the Fifth Circuit more or less agreed with it. The dissent, not so much. Okay, so those are the first two parts. Is there standing? Number one. Is the mandate constitutional? Number two. So far, I'm on pretty solid ground, I think. And if the court did nothing else beyond saying the mandate was unconstitutional and stopped there, I don't think Richard would actually care very much. Maybe he would, but he's shaking his head. But if the court just said the mandate's unconstitutional, go home, right, you're done, I think people frankly wouldn't care. And I think I would take that as a victory. But we go to the third question, which is the question of severability. And this is where really all the marbles are. Severability is a funny doctrine in the courts. And it asks, if Congress enacted a statute and they knew that provision X would be declared unconstitutional, what would they want the remainder of the statute to do, right? And I use a very gross example, but it helps a little bit to describe it. Think of gangrene, okay? Follow me here. Let's say you have gangrene on a toe. What's the remedy? What do? You cut off the toe and you're probably fine, right? Let's say the gangrene spreads to your entire foot, or maybe you have to amputate the foot. And maybe the gangrene spreads to your lower leg below the knee, you amputate below the knee. And maybe the gangrene spreads to the entire body and the patient cannot be saved, right? Sometimes there's some infection that infects the entire body politic, so to speak. Severability works in a similar fashion, right? It's possible that you just declare the mandate unconstitutional and leave the rest of the law in place. Or maybe the remedy is you declare the mandate unconstitutional, plus certain provisions that protect those with pre-existing conditions, what's called guaranteed issue and community rating. The argument is the ACA would not have been enacted with these protections for sick people unless you had a mandate to buy insurance. Or maybe the argument is you kill the entire law itself, right? That the ACA requires the mandate, and without the mandate, nothing can go forward. On this part, I am actually somewhat, undecided is the wrong word, but I'm of multiple minds. Here, let me walk you through my thinking. In 2012, the Obama administration argued that if the mandate goes, so must the guaranteed issue and community rating. These are the protections for sick people in the law. That argument made a lot of sense in 2012. In hindsight, though, it may not make a lot of sense. Why? It turns out the mandate wasn't that important, right? That wasn't known in 2010, but in the years since, the mandate didn't really play an important role. What's actually played an important role is not the mandate, but the subsidies, right? When you buy an Obamacare policy, you get lots of free money from the government, they subsidize your policy. That's what helped make things tick. So does the 2012 position make sense? Maybe yes, maybe no. In 2012, the four joint dissenters, Scalia, Kennedy, Thomas, Alito, argued that if the mandate goes, the entire law must go, that the mandate's like the linchpin of the entire statute. I think that was also probably a reasonable argument in 2012. Unclear if it's a reasonable argument now. Now, why am I saying unclear? Usually with severability, we ask a question, what did Congress intend? But that's a question that jumps the gun a bit. Which Congress? The Congress in 2017 that enacted the tax cut law? Or the Congress in 2010 that enacted the ACA? Which is the relevant intent? And I think actually this is a question which the courts and the precedents are somewhat unclear, right? When a later in time Congress takes an action to render an earlier in time statute unconstitutional, it's not clear to me that what the later in time Congress did is relevant. They screwed up. And I'll make my point bluntly, maybe the remedy should be, we kill the tax cut, right? If you restore the tax, the $100 penalty, the $800 penalty, everything's fine. So maybe the remedy is you just reinsert the tax and make Obamacare constitutional. I think the outcome is unlikely, but I think it'll be entirely sound with precedent. Okay, now let me give you another option for severability. A couple of years ago, Justice Thomas wrote a decision called in Murphy versus Ncaa. This involved online sports gambling, nothing too critical. And Justice Thomas made a point about severability. Justice Thomas explained that our entire severability jurisprudence is somewhat backwards. Right? Usually we ask, does a party have standing to challenge a law? And if they have standing to challenge a law, then the courts can declare that law unconstitutional. But with severability, it goes almost backwards. We ask, well, if the party is standing to challenge one part of the law, we can then kill the entire law, whether or not there's any injury in fact. And Justice Thomas says that goes a bridge too far, that we should ask on a case-by-case basis what provisions injure the plaintiffs, and only those provisions that injure the plaintiffs can be declared unconstitutional. This is what I think the Fifth Circuit was actually trying to do with their opinion. The Fifth Circuit didn't declare the entire law unconstitutional. In fact, there's no injunction in place now at all. Rather, the Fifth Circuit said this district court messed up. Right? Why did the district court mess up? Because he just declared the entire law unconstitutional without going line by line. The Fifth Circuit issued what's called a remand. They sent it back to the lower court saying, hey, take another look at this. Figure out what provisions injure the plaintiffs, and depending what injures the plaintiffs, then you can declare what should be severed and what should not be severed. The upshot is, I think less than the full law is gone, but some provisions like the guaranteed issue probably would be gone under this approach. Okay, so there's a different approach to severability. I am partial to the Thomas solution, which is why I'm conflicted. Justice Thomas's solution is completely inconsistent with case law that's fairly long-standing, but I think it's correct as a matter of Article 3. And I think if Article 3 is the reason why you do it, then it doesn't matter what the precedent says. I think you can't have judges trying to discern the intent of two Congresses a decade apart. I think it's a very fraught inquiry. Okay? All right, so now where are we now? We recently had a decision from the Fifth Circuit, and there was an appeal. We had an appeal from the California Attorney General, that's number one, and from the House of Representatives General Counsel, that's number two. I don't think the House has standing. Maybe I can answer that in Q&A. But I think as a general matter, houses don't belong to Congress. I think there's some precedent against it that's fairly strong from the Supreme Court. So I think the House is basically out of the case. California, though, I think has standing. There's no question that the state would lose funding under both the Medicaid expansion and some other provisions that the state is injured. So the state of California filed what's called a motion to expedite, right? They asked the Supreme Court, can you please hurry up so we can hear the case this year before the end of the term that is decided by June of 2020, meaning you would have a decision before the election coming up in November. Yes, we have an election, remember that? An election coming up. The Supreme Court, without any recorded dissent, denied the motion to expedite. The consequence of that is the briefing will wrap up actually in the next couple days, and I think we'll see a decision in 2 or 3 weeks about whether they're going to take the case. I'm of a mixed mind. You probably know it takes 4 votes to grant certiorari, right? 4 votes. You need 5 votes to decide a case, but only 4 justices to grant review for a case. Generally, the Supreme Court would not take a case in this preliminary posture. We only have basically a remand. We don't have an injunction in place, right? This is so preliminary. But then this is not a regular case. This is Obamacare. And usually when the rules involve Obamacare, everything goes out the window. So it's entirely possible that 4 of the more progressive justices vote to grant cert to force this issue in the election season. And depending when it's argued, it may actually be argued before the election. And I predict, my friends, I predict that the arguments will make their way into a campaign ad. This ad's paid for by Michael Bloomberg, right? He's everywhere, right? And they'll have the Trump Solicitor General arguing that the law and its popular pre-existing condition coverages should be set aside by the court. So I think if it can be done, that the progressives will try to make it be argued sooner. Not sure if that's good or bad. I've checked the calendar for the fall. There are mostly there are a couple dates before the election, most of them afterwards, so they have to hustle. But it's feasible. Now, what will the Supreme Court do? Oh, I don't know, my friends. I've stopped making predictions about John Roberts. He continues to surprise and disappoint me on a daily basis. I don't know what he's going to do. I think it's entirely feasible the court holds that they're standing, and the mandate's unconstitutional and stops there. Again, I'd be okay with that. The severability one's not the actual issue I care about. But it's entirely possible the court holds that Justice Thomas is right. And the correct remedy is to go line by line through the statute to determine what injures the plaintiffs. And if that's the case, this case goes on hold for about 2 years for a trial. You're a good trial lawyer. Maybe you can litigate this one, right? This is going to be, I don't know how you litigate that question line by line of a 4,000-page statute, not to mention the thousands of pages of regulations which have been issued pursuant to the statute. So in other words, this case is messy. I don't know what the court does here, but I'm at least fairly confident that they're standing. And I think I'm fairly confident the mandate's unconstitutional. But once we get to severability, I have no idea. How am I on time? Thumbs up. Thank you all so much.
So this is interesting, though. A couple things here. I'm actually not going to disagree that much with this one yet. I'm probably not going to disagree that much with a lot. I think we actually have similar thoughts on some of this. Obviously, ultimately, we can get a different outcome. Just to sort of inform and full clarification to so everybody knows, I'm really not, so I personally, the way I came to this is I actually kind of historically been involved in the Federal Society side of things, I go to the National Convention, stuff like that. I actually, done a lot of stuff with Liberty, First Liberty, whatnot. So I really am not like the far left person. It was funny when the ACLU decided to sign our brief, I actually kind of freaked out. Because I was kind of like, oh crap, I'm never going to be a federal judge now. I'm burned. I'm like totally burned. So, I mean, the real way I came at this is I do a lot of pro bono work with disability rights organizations, special education, things like that. And I've had a lot of great experiences doing that. And they came to me on this and they said, you know what, our organizations care really deeply about this. And the reason they care deeply about this is because there's probably no population in America that's more profoundly impacted by the ACA and by the implications of playing that in the disability, the individual with disabilities population. They are profoundly, there's one statistic I wanted to read here that I think is really interesting. The majority, in 2017, the majority of Americans without disabilities, 65%, obtain health insurance from employers. However, the statistic flips around completely. In 2017, only 34% of those with disabilities receive insurance from employers. And part of that is the nature of folks who have disability. A lot of times they be self-employed, they end up getting kinds of career paths that don't give them the same access to insurance. And the problem that the background on it is it really creates chaos. I mean, as a partner in a large law firm, I actually technically am self-employed. One of the horrible things you find out when you partner in a law firm is you no longer get your insurance subsidized. And so for my family of 4 kids, and my wife and I, it would be $34,000 a year in premiums that we need to pay, just monthly premiums, $34,000 a year. So what we've actually been doing for the last several years is Christian co-ops, which you can join, which actually were created in part because of the ACA. And they actually had, in the original version of the law, they actually got you out of the tax code. So you actually could avoid being penalized if you joined a Christian health co-op, which is fundamentally different. And we've actually been doing that now for the last couple of years. It's actually been really good. It's actually worked pretty well. But see, here's the thing. You can do that because we're all healthy. They don't get any pre-existing conditions. If you have any major medical problems, disabilities, things like that, it's not going to cover. It's essentially the health co-op for healthy people. And so there's a huge population of millions of Americans who look at the ACA, and for all the things that we may hate about it or love about it or whatnot, they look at it as a critical part of them being able to have some insurance. Otherwise, they have no chance. And so that's really, so the angle that we came at it was really representing these groups. And then some of the ACLU jumps on, I'm like, oh my gosh, no. But that's essentially the angle we came at it from. And sort of going at this, I mean, there actually are a few angles, so I think we have a lot of common ground. Talking through the first 3 things, the standing, the constitutionality. Constitutionality I'm not really going to address. I mean, Robert's opinion is the one that really dictates that. He finished it all on that. It is what it is. But when you look at the standing, it's a weird concept. It really is. I mean, it's kind of a legal fiction that this is standing. The one thing I will say, though, is when the Congressional Budget Office was putting together their stats on this and why they need the mandate, one of the things they pointed out was that even if, I actually had this written down here somewhere, at least I can give the exact numbers, it's kind of interesting. It's not in this version of the training. They, one second here. Oh yeah, okay, so when figuring this out, the Congressional Budget Office reasoned the repeal of the mandate would reduce federal expenditures over 2 years by $338 billion. But they opined that the repeal of the penalty would reduce expenditures by only $218 billion. Why the difference? Well, that $20 billion difference is because they believed it was a population that would still get health care because the government told them they had to, even without a tax penalty. Which seems wacky to me, but people do that kind of choice, right? And so the government's telling you to buy something, arguably they were standing. Now, having said that, then we get into the interesting issue that Josh raised, which is that Thomas concurrence. And I actually do agree that's what I think the circuit was doing there as well, was really adopting that approach. And that does mesh the standing a little bit then, because suddenly you really have standing to challenge the whole thing, and it kind of puts all back on itself. So I think standing is a little more complicated. At the end of the day, I also agree that if the court says standing and constitutionality, but it's severable, nobody really cares. Okay? So I'm going to jump ahead really to the severability of it. And the severability of it is just absolutely, to me, crazy. I look at this, and this actually ties in for me to a bigger point, which is the politicization of the judiciary. And I frankly find it really depressing. I think we live in really partisan times that anybody who's been watching impeachment stuff going on, it's just depressing, right? I mean, it doesn't matter, what side of the aisle you might be on. Everybody just sort of digs in and goes for it. And what we have here, so the history of this particular case, it started out in Reed O'Connor's court here in Texas. Well, why Reed O'Connor's court? Because the reality is Reed O'Connor, and he is a, fan of federal society, so I don't want to be too mean to the guy, but he's kind of a hired gun, sort of maybe, okay? If you want to take something to the Obama administration and have it declared unconstitutional, you do it from Reed O'Connor. And that's what he's going to do, he's going to put that. Here you go, unconstitutional. Okay, great. And so that's what happened here, right? So he declares the whole thing unconstitutional, up it goes to the Fifth Circuit. You get a panel, the first panel, three-judge panel. You have two Republican appointees and one Carolyn King, who is
Carter.
Carter, which is that's a long time ago.
So.
Yeah, I mean it's been. Geez, I could tell you all about her. I've worked on Fifth Circuit, and that's too many people whole panel for her, but nice lady. But in any event, though, of course, how does it go? The two Republicans, Ron and Nard, come down saying, it's unconstitutional. And of course, she comes down and says the opposite. And it goes to the en banc. That's the en banc over again. 8 Republicans.
Except Jerry Smith.
Except Jerry Smith, who's kind of a wild card. And then he wins on the other side. And I mean, it's just kind of depressing, right? And we know it's going to go to the Supreme Court. Either now or later, it's going to go to the Supreme Court. What's going to happen to the Supreme Court? It's going to be, the 4 and the 4, and then Roberts can decide what Roberts wants to do. I mean, it kind of, to me, there's a fear there that diminishes the whole practice of law, of what we do, what we all aspire to do, to really, I'm sorry, if we can do that on napkins. It wouldn't make a difference. Okay, it really wouldn't. And so that's really what we're dealing with here. But so on the severability issue, I do have to look at this and say, how on earth, the point of construction, of what the courts are trying to do here, is ascertain what was Congress's intent. You've got to go back and you've got to look at what was going on in Congress. And you've got to see that, okay, in 2010 we had this version of a statute. We have a statute that's created. We have this whole law that's enacted. The law we're talking about right now, though, I would say is another law, fundamentally, is a different law. It's been edited, but when you edit something like that, you change it. And when you got the Republican Congress in place, the Republican president, what was the big promise they've been making for years? We're going to repeal and replace Obamacare. Repeal and replace. Did they? No. Because they didn't have the votes. They didn't have the votes because there's parts of Obamacare, there's parts of the ACA that people want. There's parts of it that people actually want in there. And they couldn't do what they wanted politically. They didn't have legislation, could not go through and keep the whole thing out. So then what we had was that dies down, which will come back to reset every day, and then you have the tax cut bill come through. And that's when they zero out the tax cut, which has that effect, absolutely. Now here's an interesting thought for y'all to think about. And I'm curious what Josh's thoughts are on this when you get a chance to talk after this. The senators, when they did this, did they know what they were doing? Some did not, okay? Some did not. Some were like, oh, okay, they had no clue. Did Mike Lee and Ted Cruz know what was happening? Oh my gosh, yeah. So was that a Trojan horse? Was that here's a cyanide pill, go ahead and swallow this down? I mean, that to me, it's like some serious three-dimensional chess going on right there. that we're basically setting this all up, but we can't repeal and replace it. But we can go ahead and just murder the whole thing and make it unconstitutional by slipping in this and knocking out the mandate. Look at that, look how awesome and smart we are. So that worries me. I mean, that profoundly concerns me. So when I look at severability, though, I have to ignore whatever the cunning thoughts were of Ted and Mike, and actually say, well, okay, what really was Congress with the capital C collectively? What were they doing here? Well, they were doing a scalpel because that's all they had their votes to do. If they had gone and actually been fully upfront and said, we're introducing this bill that has this provision in it that's going to ultimately render the whole entire ACA unconstitutional, and instead of repeal it with no replacement. Wah ha ha ha. That's not going to pass, folks. That's not going to get through. So I think we have to look at what they actually did through and what the congressional intent was. And with the congressional intent, we got a statute here, and actually really did a scalpel. They went in and they very carefully carved out what was the most noxious, most unpopular provision, which is that tax penalty. They cut it out. They left the whole rest of it. That is a fundamentally, to me, different statute. It's a different act. It's a different law. It's different. And at that point, I don't know how you can have it. Now there is some language. If you go back to 2010, Josh, right, there was some language in there that they made it sound like a mandate was the most important thing in the world. We have to have this. Everything is essential to everything. And part of the reason for that is because insurance companies, you can't just insure sick people. You have to make the health people sign up too. And there's reasons for that. There's a lot of rhetoric you can create that makes it sound like that. But when we look at the version of the law that we currently are sitting with, I don't think we can look at congressional intent and come away with anything but the fact that it was intended to be severable. They essentially severed it. And so that's essentially where I come down on this. Now, as far as, the Fifth Circuit has given Reed O'Connor the direction to go back, finer tooth comb, go back through. The problem is this. Now, is it going to be given cert or not? Maybe. I think maybe Josh is right about that as well. I think we agree that there's reasons the court very well might pass on cert, because typically when you have a return like this, since you go back into further consideration of district court, you normally wouldn't want to jump into that. You want to go into the process. Let the process run. But the real problem we're dealing with here is a couple of things. One is a need for certain things. There's obviously the political component, election year, all that. But the Supreme Court already did not do expedited review. So we're not going to be getting a decision on this thing before the election. At most, if they can rush and squeeze it in, they might be an argument in advance of the election. But when I look at that, what I really see is a court that can go over way and things like they very well might let this play out. The problem is let it play out. We have a huge population that is really saying, well, we'll do this with us. We need certainty. Good or bad, we need to know what's going on. We can't be in this limbo, not going to know. That's why I hope circuits there for that reason, because otherwise what's going to happen is you can go back and go Congress court. And I don't think there's a lot of confidence among those who want to see it upheld that Reed O'Connor, with his finer tooth comb, would do anything but declare the whole thing unconstitutional. That's essentially the viewpoint. I mean, it's sort of like me using finer tooth comb. It doesn't give me a whole lot of it. I don't think Reed O'Connor necessarily is going to do much there. So what we're going to get is another opinion saying, using my new comb I found, that this is still all unconstitutional. And it's going to go back to the Fifth Circuit, and we're going to have the same en banc, because it's going to end up being an en banc vote again, and it'll be, assuming nobody dies and is replaced, in the same numbers again. And then it'll be back to the Supreme Court. I mean, it all sounds very depressing. But that's sort of what we're standing with, right? And so I'm hoping it gets circulated, but I don't think we have any way of knowing for sure. And I think at the end of the day, it's going to be what John Roberts wants to do. Now there is the wild gamble, which is this drags out a little bit. If hypothetically, Trump gets reelected, Ruth Ginsburg dies, and then it gets decided, and you have another, Kavanaugh, Gorsuch, type up there. Well, we know what's going to happen. It's all unconstitutional, right? In the meantime, somebody else wins, and like Justice Thomas, what will happen, who knows what, then go that direction, we really don't know. That's all. So in any event, that's my sort of depressing take on it. I mean, it's funny, we read all these briefs, we spend all these pages, and put so much effort into it, and treat like the most important documents ever, but like I said, we get that happens. They really could. I mean, it's just really Justice Robert wants. So that's my depression.
We live in John Roberts' world,
We do.
and we're just laughing. Well, I don't have any combs or anything else to share with you. Let me address a few high-level points. So the first question my friend posed is, were there senators in 2017 aware that dropping the penalty to $0 would make the law unconstitutional? I've scoured with a fine-tooth comb the legislative history. I can't find anything on the record. But if someone like a Ted Cruz or Mike Lee, both SCOTUS clerks, they must have known, or at least their counsel figured out. How do I guess that? I knew it, right? When this was going on, I was like, wow, Obamacare is unconstitutional. Look at that. Like I wrote various blog posts over the years about how, long story short, in certain places, Obamacare became so expensive, the penalty became coercive. It was so much money. I was fully cognizant of this fact. So if I was, I guess Cruz and Lee might have been as well. But then you have someone like Susan Collins, who's the other most important woman in the world, saying in the record, of course we're just decreasing the penalty, nothing else. But very often Congress does stuff, and the consequences of what they do go beyond it. And I'll use an example of a case of the court this term, the Title VII case, right? When Congress enacted Title VII in the 1960s, could they even fathom that they'd be protecting a sexual orientation or gender identity? Of course not. It'd be insane. The argument is not what Congress intended, it's what they actually did. Very often the consequences of your action are different than what you intend, which is why I'm nervous in general about congressional intent. I'd rather take Congress at their word rather than what was in their minds. Now, as for the sort of politicization, I can't disagree with Richard. It's kind of unfortunate, but I will give Reed O'Connor some credit, mostly because he cited me and he used my analysis. So it's
Brilliant.
Pitbull, right? Yeah, Pitbull, right? So I think Reed makes some good points. I think if he really wanted to be a Pitbull, he would have denied a stay. He stayed his ruling, right? I mean, district court judges make mistakes, but as long as they stay their ruling, nothing changes. And I do think Reed will take a second look. He was not applying the Thomas model. He was applying the more or less model I would have, not exactly, but the more or less model I would have thought about the competing Congresses. So I don't know what Judge O'Connor will do. I think there's some minor provisions of the ACA. For example, you go to a restaurant now and they have to post the calorie counts on the sign, right, when you buy something. That's a fairly minor provision. I don't know that it injures everyone. So there might be some small stuff that's saved, but the big stuff, the pre-existing condition protection, the guarantee issue, I think that all will likely be on the chopping block. Now, what will John Roberts do? I feel this is like $1 million question. John Roberts, I think John Roberts thinks he's doing the right thing when everyone's mad at him, right? When everyone's upset, that means he's doing the right thing. So even at the impeachment trial, he yelled at both sides, like, be nice, don't use mean words in the Senate. He declined to vote to call witnesses. He said, it's not my role as an unelected judge. So I can't tell you what he's going to do. But if this does drag out another 2 years and we have another nominee on the court, then John Roberts becomes, not so important anymore. And I don't know what happens there. But let me leave you with one thought. Congress could kill this lawsuit in 5 seconds. How? Enact a one-page bill that repeals the mandate. A one-page bill that repeals the mandate, this case disappears tomorrow. The only basis for this suit is the existence of the mandate. Now, why won't Congress do that? I think, frankly, the Democrats in Congress like the political pain. They want to twist the screws on the Republicans. I think they won't do that. If they pass a one-page bill repealing the mandate, this case would go away. It's an unpopular part of the law. It's not actually an essential. Kill it. But I think they'd actually let it ride. Now, the question is, if we're at the Supreme Court, the doorsteps, and the court's about to strike down the entire law, you pass this one-page bill to moot it? Absolutely not. I think they let it ride. And I think that suggests that the political pain might actually be part of the plan. Now, this inures to the detriment of Republicans, big league. No Republican wants to kill Obamacare, except for maybe Cruz and Lee, I don't know. But this one blows back on the GOP if the court actually kills the entire law, because there's no meaningful backup. This law is so deeply entrenched in our polity, you can't pick it apart with a fine-tooth comb or something, right? So I don't know how this one ends. I will write another book about it. I've had 2 Obamacare books. I'll have a 3rd one coming out in 2022 or so. I'll let you know how that one turns out. All right, I think that's all we got, and I think you have some questions for us as well. Thank you.
starting with standing, can you tease out the standing issue a little bit more? Specifically, why is it that plaintiff states can bring a challenge, and how exactly do you identify injury to a state?
I only spoke about standing for individual plaintiffs. There are two Texas individuals who said, we don't want to have to buy insurance, we don't want to pay the penalty, we don't want to do anything, we will buy insurance. I think their standing claim is actually strong, or maybe even plausible. The states have a different standing argument. Texas, as you probably know, is an employer. They have lots of employees. And the ACA imposes various reporting requirements on employers. But here's the disconnect. The mandate doesn't apply to the states directly. Rather, the mandate applies to the workers. And because the workers then have to get insurance, that imposes additional burdens. So it's like one layer removed. It's the mandate applies to workers. Workers have to because the Fifth Circuit found the states have standing. Because when we're talking about the fine-tooth this comb, we look at not only the injury to the private plaintiffs, but the injuries to the states. And that's where Medicaid comes in as well. I don't think the states have standing. Private individuals, both in Austin, who don't want to buy insurance.
I agree with that. I mean, I think the House of Representatives standing is a little more interesting. That one I actually, struggle with a little bit too. I think that seems more. But the bottom line is they've also brought in real, which their briefing could arguably be considered better briefing when you read it. I don't know what your thoughts are on that. But
He's not arguing it though.
Well, yeah.
Yeah, and I think I know another reason why. So in 2012, the Solicitor General is Don Verrilli. He argued the Obamacare case. And now he's in private practice, but Verrilli's come back and signed up for the House, pro bono, I'm sure, to argue it. But he hasn't argued the cases. I think he would be in a tough spot. And the reason why is because he made some arguments on severability and the mandate that are in tension with it today, and he might actually get boxed in. Yep. So I think it's better not to have him up there. It actually, if you made a different argument in your prior practice, you're not bound by it by any means, but the optics are bad. So I think they let Doug Letter argue it.
Yep, I think that's right. I think that if he gets up there, he is boxed in. When you're arguing as a lawyer, it's not, especially with SCOTUS, it's not as easy to consider as impeachment. I'm sure you guys have seen the video from the Clinton impeachment. They're like, it's got to be this way. No, it's got to be that way. You can't look at it as a lawyer. And I think if it really got up there in the Supreme Court, I think he'd have a pretty hard time with some of the positions. But he is, the reality is on the briefing. It's a situation we see outside of, it's not that unusual in any setting. I've had lots of cases where there's another party that just really, and a lot of times they have deep pockets, or they think they're better, they're smarter, they know more, whatever it is. And they desperately want to have their voice. They want to have their soapbox to say something. And that's really what House of Representatives, what it really truly is about, is giving their soapbox to give them a say. They're legally not necessary. But it's almost like, I view their briefing almost as like an amicus brief on steroids. That's right.
I agree.
So moving to severability doctrine and where people usually fall on ideological lines and just decide how to place they move on.
Go first.
I think the severability doctrine is amazing because for exactly that reason, I think it defies ideological lines. I think we're seeing a lot of folks really struggling, who want so badly, who are on the conservative side, who want so badly to be kill ACA, rah, 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 and you look at it legally, you're like, it really is hard. It's very hard to look, especially the O'Connor, the original O'Connor opinion, when he just essentially rubber stamped and killed the whole thing. On that, I think it's really, really hard. And I think, again, the approach to severability that we're talking about that frankly requires really saying you have standing to challenge this part and this part, which is really pro-severability, pro-sever it out to a large extent. A lot of that comes from Justice Thomas's concurrence, and I don't know what he is ideologically. So to me, it really defies ideology. If anything, I almost feel, frankly, like true conservative or federalist principles as far as severability would cut in favor of severability. But it gets hard.
Well, let me give you another example of a recent severability case that cuts the other way, involves abortion. You may recall Texas enacted several very restrictive abortion laws some years ago. For example, you have to get admitting privileges to a hospital nearby. You have to have your facility have ambulatory surgical standards, right? Even if you don't perform surgery. But the law has some other fairly mundane principles. So for example, you have to have smoke detectors installed. And your hallways have to be a certain width to fit gurneys, fit a stretcher. Justice Breyer's opinion, Holman's Health, basically said the entire law has to go, right? Even the provision requiring smoke detectors in abortion clinics has to go. You can't even sever out some of that smoke detector, which seems completely innocuous, right? Why would you not have a smoke detector in a medical facility? So again, Richard and I think are more or less on the same page. Severability doctrine is incoherent. It's a mess, and it doesn't always cut right left in any predictable ways.
It is, I do think it's really important though. I mean, I think the severability doctrine is what's so fascinating to me about it, is it is a moment to actually, during this everything I've said, and sort of my deep, profound impression about how political all is that we do have to have some goalposts or some signposting here where, no, actually, we do believe this is the law. And we can't bend over to let that go just because we want this outcome. Because once you do that, it's like chaos. And that's the big thing.
So given that, and we're getting a little bit of guidance from the Fifth Circuit, for both of you, where is the line on severability? Like what exactly stays, what exactly goes? Can you give us a little bit more detail?
Oh gosh. It's hard.
Look, I think in 2012, the Obama administration got the severability question right. I think if the mandate goes, then a guaranteed issue community rating goes, which I think will be devastating for reasons Richard mentioned. I mean, Congress could just reenact those same two provisions in a fairly short statute, right? I mean, law students think, oh my God, the Supreme Court killed Obamacare, that's the end of the world. Look, if there's some parts that are popular enough, you can reenact the statute fairly quickly. So it's not the end of the world, but I think people on both sides of the aisle will try to inflict political pain and not go along with even what is fairly popular. As some slight consolation, a lot of states have on the books guaranteed issue provisions that predated Obamacare. So even if the federal one goes, a lot of states would have it. I don't think Texas does.
I think I agree with that. I think it's one of those interesting issues too when you have Congress can fix things, right? I mean, the easy solution on this, and part of the reason severability in these documents are structured the way they are, is the belief that, well, a legislature can always go back and make it right. You can kill it, say it's unconstitutional, you can go back and use powers and actually get it and fix it. The problem is, though, I don't know if any of us really truly believe Congress currently can do that. I mean, and then that's sort of one of the problems, is they may technically have the ability or the possibility of doing that, but then are they actually going to? And then the reality is, if the ACA gets struck down as unconstitutional, I would love to say that Congress will jump back in and fix it and put in that first position.
And this would be my last question.
So we've seen in recent, I don't know, past decade or so, depending how you count, these 28 state coalitions where they all challenge federal government. And you see this in different ways, right? All 28 states file in a single forum, or you have a dozen states file in different forums, right? And this, your question is overlapping with what are called nationwide or non-party injunctions. I don't have a problem in the abstract when 28 states go to a single court, even if they forum shop quite effectively, because at least you have a single judge. I am troubled when 28 states go to 28 different courts, which makes it basically impossible for anyone to, it makes it impossible to defend, because the second one judge issues a nationwide non-party injunction, the other courts don't matter anymore. So you could win 27 cases and lose one, and you're done. Like I do litigation involving 3D printed guns. Is my case over the summer. I had 4 states sue me in 4 different courts. I won 3 of them. Yeah, go Josh, right? fourth one issue a nationwide injunction, didn't matter, right? So as a litigator, it really sucks to win 3 and lose a fourth one. The 3 that you won don't matter anymore. So I don't know that the Supreme Court may rein in these sort of non-party injunctions. I think they're problematic, but I don't think inherently wrong with attorney generals suing the federal government. That's a fairly old thing. I think you have injury.
Yeah, I feel like we see it a lot, and I'm kind of exhausted and bored with it a little bit. It just seems to happen all the time, but I agree. I'm generally fine with that. I mean, what it does do is it enables some of them to get their preferred jurisdiction, and that's really what it is, forum shopping, and trying to get into court you want, you know, and the consolidation side is positive.
And by the way, you will all be lawyers in a couple of years. Forum shopping's good. I don't mean to be cynical, and Judge O'Connor, I'm a fan of his, but put that aside. If you have a client and you can choose federal court or state court, and one's advantageous, you make that choice. If you can choose venue A over venue B, and venue A is more favorable, you make that choice, right? If you can structure your case that it can't be removed to federal court, you do that. So I know in CivPro, forum shopping's evil, get over it, right? Forum shopping is completely rational, and I think it'd be malpractice if a lawyer did not forum shop. And I think the Attorney General is in the same boat. If there's a district where 100% of the cases go to a specific judge, and you know the judge's outlook, you file on that district. I know it's unsavory, it's unseemly, but any competent lawyer in private practice would do no less.
And I'll add to that, free tip for the day, outside of the scope of this, when you get out there in real world land, if you're a plaintiff's lawyer, yeah, state court's great. If you're representing companies and you're a defendant, you do not want state court, no matter what, ever, in a million years.
Nope.
Any possible thing you can do, you only want federal court. State court is evil. Okay.
Pro tip. All right, I think we take some questions from the students.
Chapter data.
Riveting. Yes, over there.
So you mentioned possible
Okay, so the question, if you can hear it, is reforms for non-party injunctions. You often hear the phrase nationwide injunction, which is somewhat of a misleading phrase. Injunctions apply wherever people are found, right? Whether you're in New York or Texas, wherever you go, the injunction follows you. So I think the word nationwide is misleading. But the key part is non-party injunctions, where let's say I represent a group of plaintiffs with certain interests, and we get an injunction. Now, does the injunction apply to us or every single conceivable person with similar interests? We have a mechanism in law for that. It's called a class action, where you can consolidate people with similar claims. And these nationwide injunctions are not class actions. I think Congress can get involved and create specific requirements to issue non-party injunctions. You can amend the Federal Rules of Procedure. There's nothing wrong with Congress doing that. I also think that the Supreme Court may start cracking down and saying that you should limit relief to the parties before you and not beyond that. When you have these non-party injunctions, you get these states to the Supreme Court, and they don't like doing that. One other option that I think would be helpful, but I think is unlikely, is we return to the 3-judge panel model. For many decades in federal courts, if you wanted to challenge a law, you didn't just find the random district court nearby. You would assemble a 3-judge panel in D.C., perhaps, and all cases are consolidated to that one panel. So, for example, if you challenge provisions of campaign finance law and the McCain-Feingold law, you have one forum. You file in the District of Columbia. You have 3-judge panel. It's 2 district courts and 1 circuit court judge, and that's it. And anyone who has a problem goes to that same forum. Right now, there's forum shopping in the D.C. Circuit for sure, but you're stuck in that court. You can't choose anywhere else. I think that would be healthier than having, think of the travel ban litigation, right, where you have 15 forums, judges issuing nationwide injunctions left and right. I just don't think that approach is healthy.
I agree. Yeah. I mean, on that one, I do worry a little bit about the DC Circuit concept of that, because it usually emphasizes so much. It puts so much power. It vests so much power at that point.
Yeah, I mean, maybe any challenges in Texas are brought before a 3-judge panel right away. In other words, you don't have this business where you get a district court judge, you get the panel, and you get the en banc. Just cut to the frickin' chase, right? Get a 3-judge panel, and it goes mandatory review to the Supreme Court, and that might be another model to toy with.
And that to me will work better. I mean, I worry a little bit. I have a big issue with sort of the East Coastization of law, to where everything is, Yale and Harvard grads in D.C. and New York, and it just gets tiring. So I like to avoid that. I mean, the federal circuit, obviously, for IP cases, has been doing that model for a while. I don't think it's necessarily, if you put your IP, but I don't think it's necessarily always been a great thing. I think it's some downsides to it. So.
Very good. Maybe one more question before we head out. Going once, going twice. Thank you so much.
For me, and thank you.
Thank you, very good. Thank you.